The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. With these words, the Fourth Amendment to the Constitution of the United States guarantees us the right to privacy. But in a nation of over 200 million people, how far does an individual's right to privacy extend? And what constitutes an unreasonable invasion of privacy when a person is suspected of having broken the law?
Mr. Anderson, how do you like your apartment?
Well, it seems fine, thanks.
Good, And do you have enough closet space?
Oh, yeah, I think there's plenty, thanks.
You know, we do provide maid service, and that's included in your rent every 2 weeks.
Oh, thank you very much.
Linens are extra, though.
Oh, all right, thanks.
And you're going to need a car sticker on the windshield of your car to park down below.
Oh.
If we didn't have that, why, all the neighbors would be using our lot, and the tenants wouldn't have any place to park.
I can understand.
You can get a car sticker from my husband and me whenever you wish.
Oh, thank you very much.
Okay. Any other problems, you need anything, just let us know.
On Johnny B until he pays up his account, so if he calls, well, you tell him that, okay? Hello? Okay, 20 across the board on Wandering Hombre in the 5th at Hollywood Park. You're on.
Yes. 10 across the board on Shelter Bay in the 3rd at Hialeah.
Okay, Pride of Ireland.
Okay.
100 to win. Well, that was 50 to win, okay. Pride of Ireland, 50 to win. 3rd race at Caliente. You're on.
We're getting it.
Good. I'll see you in the morning.
Hello? I can't take that bet. The race is closed out. Okay, bye. Man, I'm gonna split. I'll see you in the morning, okay?
Okay, man. See you tomorrow.
All right, ciao.
Hello. Yeah, baby, how are you? I can talk for a minute. Okay, I'll see you at 10 o'clock. Just dress casual.
Are you the affiant named in this affidavit?
Yes, sir. Lieutenant Anderson, badge 321 City Police. I prepared the request for a search warrant.
I have checked it and find that the real property to be searched is adequately described. I note that the person to be searched is Sanford Lester. Is that correct?
Yes, it is, Your Honor.
And he resides at the property described in the affidavit, does he?
Yes, Your Honor.
I also know that the articles of personal property that are to be seized are bookmaking paraphernalia. Is that correct?
That's correct, Your Honor.
Now, what was the source of your information leading up to making this affidavit?
We eavesdropped using a parabolic microphone.
Was a trespass committed on the premises to do the eavesdropping?
No, sir. There was absolutely no physical intrusion onto the premises of Mr. Lester whatsoever.
As a result of your investigation, do you feel that there is probable cause for a search
Yes, I do, Your Honor.
of these premises?
Yes, sir.
Will you raise your right hand, please? Do you solemnly swear that the statements made in this affidavit are true and correct?
Yes, I do, Your Honor.
20 to win, 10 to place on chess player in the third at Caliente. Okay, you're on.
Police officers, open the door. We have a search warrant for these premises.
Just a minute, I have to get some clothes on.
Come on, let's open up here.
Man, I'm coming. Okay. Can I see your search warrant?
Hey, man, I'm just sitting here reading a book. Treasure Island, Robert Louis Stevenson.
Okay, we've got enough. Let's take them in.
Law offices.
Mr. Mike Harper, please.
One moment.
Yes?
This is Sandy Lester. The police just raided my apartment, and Tom Johnson and I are busted on a bookmaking charge.
Where are you?
At the University Station on the west side.
Have they set bail yet?
No.
What's the story?
It had to be that the apartment or the telephone was bugged. That's the only way they could have got to us.
Don't sign anything, and don't talk to the police officers. After I check into the bail, I'll look into the search. If what you say is true, your constitutional rights may have been violated, and we can file a motion with the court to throw out the evidence that was seized in your apartment.
We are about to watch a pretrial hearing. It will not determine the guilt or innocence of the accused. The defense attorney has asked for this hearing because he feels that the evidence found by the police should be suppressed. That is, not used in court. Why? Because he believes the surveillance carried out by the police was an invasion of the constitutional right to privacy of the accused, and the search warrant used to gain access to the apartment should never have been issued on the basis of such a surveillance. The district attorneys representing the state feel the surveillance was not an unconstitutional invasion of privacy. Thus, the search warrant was valid, and the evidence seized should be used in trying the accused. The judge must decide if the constitutional rights of the accused were violated and if evidence should be suppressed.
Directing your attention to March 9 of this year, what was your assignment in connection with your duties as a police officer?
I was assigned to conduct visual and electronic surveillance of an apartment located at 215 Ardmore in the city.
Isn't it a fact, Lieutenant Anderson, that without the aid of this parabolic microphone, you could not have overheard what was going on in Mr. Lester's living room?
That's true, sir.
Well, I think it's clear, Mr. Harper, on the basis of what I've already heard, that there was probable cause for the issuance of this search warrant. That is, if the information the officers obtained by listening over the parabolic microphone is admissible in court and therefore can be the basis for a search warrant. So I take it that your position on this motion is that that information is not admissible and may not be used by the court to uphold the search warrant.
May it please the court. The police officers who testified here have admitted what they did. They invaded private premises by means which, if generally adopted, would leave no man safe from governmental prying into his most private thoughts and conversations in his home, his car, his office, or anywhere else. Without a warrant, a parabolic microphone of conceded range and accuracy was installed in an apartment many feet away from the apartment of the defendant Lester. And the police listened in for more than a day to every conversation that took place in the living room of that apartment. Then the police went to another judge of this court and obtained a warrant for the raid. We contend that that arrest was unlawful, and that the evidence that was seized there must be returned to the defendants, so that it's not available to the state to prosecute them in this case. Why? Because that search warrant, as Lieutenant Anderson admitted in response to my question on cross-examination, was based upon the results of that surveillance, a surveillance which violated the Fourth Amendment rights of these defendants. Your Honor, the Fourth Amendment to the Constitution provides that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. We claim first, Your Honor, that this use of the parabolic microphone was a search and seizure within the meaning of the Fourth Amendment. Second, that it was a search for which a warrant is required. And third, that it was the kind of general or ransack search for which no warrant could lawfully be obtained. The guarantee of security in one's house, papers, and effects prohibits the police from listening in on private conversations. It doesn't make any difference, Your Honor, that the microphone here was planted 100 feet away, or that the police didn't sneak into the defendant's house and put it there. The Supreme Court of the United States has stressed recently that the Fourth Amendment protects people, not places. What a man seeks to preserve as private, the court said, even in an area accessible to the public, may be constitutionally protected. The Constitution forbids the government to intrude with its uninvited ear into private conversations, just as it forbids the government to send its police crashing through a man's door. The Fourth Amendment requires that before any search is made, in all except emergency circumstances, that a warrant must be obtained. Now, the police knew this rule. They obtained a warrant to raid the defendant's apartment, but for the intrusion with the parabolic microphone, for that invasion, they obtained no warrant at all. Why, Your Honor, should the Bill of Rights require them to get a warrant? Because experience has taught us that the judgment of an impartial and disinterested magistrate, a judge, if the court please, as to whether probable cause, that is, good reason, exists to search, is necessary to protect personal liberty. We simply cannot permit the police to decide on their own when to break into a man's home or to invade his privacy. Exceptions to this principle, such as when the police are pursuing a fleeing suspect, are very few and very narrow. I think I know why no warrant was obtained. The Fourth Amendment requires that a warrant specifically describe the place where the search is to be conducted and what the police expect to seize. You can't get a warrant for a general rummaging through a man's house and possessions. But the police in this case listened to everything that happened in that living room for a day or more. You can't get a warrant for that kind of a search because it is no different in the contemplation of the law from a general ransack search. The rising crime rate is a national problem, and developing means to combat it is a national priority. But that doesn't mean that every method which the police devise, no matter how dangerous it is to our fundamental liberties or to the liberties of innocent people, is permissible in the war on crime. The logical end of that argument, if the court please, would be to round up everybody whom the police suspect and put them away in camps. The late Justice Robert Jackson of the Supreme Court said, in commenting upon the power of the police in Nazi Germany, uncontrolled search and seizure is one of the first and most effective weapons in the arsenal of every arbitrary government. Among deprivations of rights, none is so effective in cowing a population, crushing the spirit of the individual, and putting terror into every heart. The men who wrote the Bill of Rights, they knew that, Your Honor, because their homes had been subject to unheralded ransack searches by British officers, searching for pamphlets and papers criticizing the king and for tea upon which the tax had not been paid. And so they wrote the Fourth Amendment, if the court please, to forbid ransack searches and to say that no matter how carefully limited a search, you had to get a warrant before you could conduct it. Now, certainly, in this process of enforcing a fundamental liberty, some men, of whose guilt the police are certain, will go free. But we invite Your Honor to consider the alternative, a society in which no man may be confident that his most private conversations may be held without the gnawing fear that the police are listening in. The Founding Fathers feared the coming of such a society, Your Honor, and the new technology of electronic surveillance makes it all too easy to bring about. We submit that the motion to suppress must be granted. Thank you.
Thank you, Mr. Harper. The court will now hear you, Mr. Dickerson, on behalf of the state.
May it please the court. Defense counsel's remarks omit the obvious. These defendants are guilty of the crimes charged against them. If they were innocent, they would not be so concerned with suppressing the overwhelming evidence of guilt that the state has amassed against them. The betting markers that were picked up off the floor, the burnt flash paper that was used as markers, racing forms, scratch sheets, and other paraphernalia of bookmaking. And of course, the incriminating conversations which were overheard. Your Honor, these defendants are not innocent apartment dwellers whose rights have been violated. They are here clearly seeking to escape conviction by taking advantage of the law. That middle place in the law, that gray area where the rights of the community to be protected from the criminal acts of the few must be weighed against the individual's Fourth Amendment rights. The right to privacy, the right to be free from illegal search and seizure. Now, we contend first, Your Honor, that there was no illegal search and seizure here. Now, Mr. Harper cites recent Supreme Court cases, and I'll quote this, which forbids intrusion by the uninvited ear into a man's private conversation. But the Supreme Court has never said that eavesdropping itself is barred by the Fourth Amendment. Mr. Justice Black pointed out in his dissent in the Katz case that the framers of the Constitution were well aware of the practice of eavesdropping, and if they had wished to restrict evidence gathered in this fashion, they would have said so in the Fourth Amendment. And by its very language, the Fourth Amendment prohibits only unreasonable searches and seizures. Now, was this, in fact, an unreasonable search? The parabolic microphone used in this instance was brought into play by the police only after their suspicions were aroused by the activities of the defendants. The defendants installed 3 separate phones in one room of an apartment. They came and went at hours that related to the scheduling of horse races throughout the country. They had arrest and conviction records for bookmaking. The suspicions of the police were reasonably aroused. Now, Mr. Harper demands that the police always get a search warrant in advance of any kind of electronic surveillance. Your Honor, I submit that there is not one case that holds that a warrant is necessary for this kind of electronic device. This case did not require entering the defendant's house and planting a bugging device or a microphone, nor was there a tap of any telephone wire. No, Your Honor, the police merely used an extension of a lawful eavesdrop. Mr. Harper compares the eavesdropping of the defendant's general conversation to a ransack search of the apartment. But there was no physical intrusion here, no breaking down of a door and rummaging through personal effects. The police in this case saw what reasonably appeared to be a bookmaking operation. Well, they could not, however, know when to switch the button of the microphone on and off to avoid general conversations which had nothing to do with bookmaking. And to expect the police to do this is asking the impossible. In short, Mr. Harper says the police should have tried to get a warrant for this electronic eavesdrop. Then he tells us that it was impossible to get a warrant because the eavesdrop is the same as a general search which is forbidden by the Constitution. What Mr. Harper is really saying is that to require a warrant for cases of this kind is the same thing as totally outlawing any kind of electronic surveillance by the police. Your Honor, we reject Mr. Harper's illogical extreme that the use of these reasonable and advanced devices result in prison camps for any citizen who is merely suspected of wrongdoing. We suggest no such thing as arbitrary search, arrest, imprisonment, or unbridled surveillance of every aspect of our citizens' lives. All we ask is the reasonable use of electronic technology to amass evidence upon which a conviction might be secured if those citizens who sit in judgment upon the accused feel that the evidence is sufficient. Your Honor, the offenses that are charged against these defendants constitute one of the building blocks of organized crime in this country. Your Honor, if we fail to use the most up-to-date methods to frustrate the operations of known hostile and criminal forces in our society, then we will fail in our protection of the well-meaning and private citizen and instead protect his criminal aggressor. And when none of us can be protected against the lawless, then those very rights that Mr. Harper is seeking to safeguard, those rights will be worthless. Your Honor, we ask that the court deny the defense's motion to suppress.
Thank you, Counselor. The problem to be decided boils down to the need on the one hand to extend to all citizens the Bill of Rights guarantee of the security of their persons and papers and houses against undue governmental intrusion. And on the other hand, we must ensure that the state has available to it the most reliable and effective and modern techniques possible to gather evidence of serious crime. Traditionally, conversations are admissible in court as evidence, even if obtained without a warrant, even if there was eavesdropping involved. To what extent do our traditional attitudes and standards apply in the new context of electronic surveillance, which requires no physical intrusion or visible presence of the hearer? Secondly, should the police have been required to take their evidence to an impartial judge for the issuance of a warrant before they were permitted to begin to use the parabolic microphone in this case? Should a warrant have been required? We must give meaning in the context of electronic surveillance to the Fourth Amendment's prohibition against general searches. It's clear, on the one hand, that the police couldn't have said in advance what conversations they were going to overhear on that parabolic mic. And at the same time, it is as important as it ever was that when we permit this sort of intrusion, we keep it limited to the narrowest extent consistent with effective law enforcement.
The concept of privacy can introduce complex problems. Should the defendants be brought to trial, or should the evidence against them be suppressed on the grounds that their constitutional right to privacy was violated?
The court will take this motion on submission, and you will be informed of the decision in due course. Thank you.
How would you decide this case?